I would like to welcome today's guest. Her name is Jehan Crump-Gibson, Attorney Jehan Crump-Gibson. Thank you so much for joining the show today. How are you?
I am wonderful. Thank you for having me.
You are so welcome. And this is primarily an audio show, hearing it through radio and then later in podcast. But we also video record the show and produce reels from it. And when you see the reels, you will see that Attorney Crump Gibson looks amazing and has shown up in her best for today's show. So we thank you for that. So how are things in Michigan? How's the weather? What do you do in a Michigan summer?
Yeah, so Michigan summers are actually beautiful. I think our fall is probably better, but the summer is great here and it's actually been pretty hot. So today it's, I think, high 80s, but it's actually supposed to be, I think, 97 or 98 tomorrow. And we're just coming off of a heat wave that produced big storms that knocked power out for days. I was out for 4 days. My neighborhood was, but we're enjoying it because anybody that's been to Michigan or has heard about it, we have very rough winters. So I try my best not to complain if it's 97 degrees.
You're like, that's a good day.
Listen, I'll take it over -2 any day.
Right. Well, wonderful. And although we're based in Los Angeles, we love having guests from around the country to lend insight on what's happening in the rest of the U.S., which can be teaching moments for all of us. So let me tell our guests a little bit about you. Again, we welcome today Attorney Jehan Crump-Gibson, who is the founder and managing partner of the Great Lakes Legal Group, a Michigan firm serving entrepreneurs, families, and businesses in commercial and real estate transactions, probate and estate planning, and government affairs. And today, she's on to really provide insights for Black and Brown and other families on the importance of probate and estate planning and the impact, for example, of the recently passed legislation, the One Big Beautiful Act, the impact of that on all of us. Many of us think it's only limited to the wealthy, but she has insights to provide that why we all should care about certain provisions of that particular act. She's also a graduate of Michigan State University and Wayne State University, a rising star, well decorated in the state of Michigan. And for those, a past president of the Wolverine Bar Association, and for those of our sorority sister friends tuning in, she is a member of Delta Sigma Theta sorority. So I'm sure you'd want to give a shout out to your sister.
Yes.
But most importantly, here to share with us today on the importance of estate planning and wealth planning for entrepreneurs, for Black and Brown families and communities and beyond. So, welcome again. Attorney Crump Gibson, give our listeners some insights as to what drove you to do the work that you do and what motivates and inspires you daily.
Yeah, so it's interesting because when I went to law school, I had no idea about probate and estate planning, right? Like in our community, obviously it's not something that we talk about. We don't sit around the table and talk about wills and trust and what's going to happen if something happens to someone. But when I was in law school, I clerked for a big bank's corporate legal department. And
Mhm.
that's when I started to see those things come off the paper. I'm like, this is what people really do? Your will and grandma in the bank trying to get added on the account and doing all these things. And so
Mhm.
that's what piqued my interest. So when I graduated from law school, and it's been over 17 years ago, that was one of my practice areas that I started. And after several years of being in the trenches of probate court and really seeing how it ripped families apart, created financial burden, and all the things that the probate process does, I said, we got to do a better job of getting the message out here. What can we do to avoid this? And there are simple steps that everybody, no matter what you have, what your family looks like, can take to make sure that they don't end up in probate court. So that's what I do. I'm tired of seeing our people get tied up in probate court and the impact that it has on them. So I'm trying to get the word out and make sure that people take the steps that they can take so that we do not have to go there.
Attorney Crump Gibson, are you by chance related to Ben Crump, Attorney Ben Crump?
We haven't figured it out yet. So I met attorney Ben Crump years ago through Wolverine Bar. So he's come to the Barristers Ball and all that jazz. So we joke and we actually call each other cousin.
Okay.
But we haven't traced it yet. But my Crump side is huge. They're from the South. So are his folks. So we haven't figured it out yet. But yeah,
Yes.
so I say, yes, that's my cousin. but we haven't figured out how yet.
I feel you. Well, that's not a bad cousin to have.
No, it is not. Not at all.
And as we just to put this show in context of time, speaking of Attorney Ben Crump, we're a couple of weeks out from July 4th weekend 2026, and we've all heard in the news of the unfortunate death of Nolan out of the state of the young man Nolan out of the state of Mississippi, and Attorney Crump is representing his family. And so
Yeah.
definitely our hearts go out to that family and go out to Attorney Ben Crump as he works to ensure that there's accountability in that case and so many others. And that case, as well as so many others, kind of speak to the untimely deaths sometimes we find in our families for young people, but for sure our elders as they near their end of their time here on earth. And so this brings into light the very much the conversation that we're having today around the importance of estate planning and probate avoidance. Also, to put this conversation in context of time, just this past weekend, one of the Senate leaders, Senator Lindsey Graham passed, and he was one of the big proponents of the One Big Beautiful Bill Act advanced by our current president. And so that One Big Beautiful Bill Act has really impacted how we think about estate and tax planning and gift planning in the US. Tell us about that from the work that you do, Attorney Crump-Gibson. That was passed January 1, 2026. So we're about 7 months out from that bill's passage. Did it take immediate effect or it takes effect
It
at a
did
later
take
point?
immediate effect. So we're operating it under now, and at least with respect to the estate planning impact. And essentially what it did, because it did a lot of different things, but I'm going to focus on what's relevant for estate planning. Before the big, beautiful bill was passed, essentially there was a threshold for estate tax. So basically, if you had assets that were over a certain threshold, you'd have to pay more tax. So you'd have to get with someone to do advanced planning to try to reduce your estate tax liability, what you would have to pay for to the federal government based on the value of your assets when you passed away. And so that would sunset depending on what was going on in Washington, right? When I first started practicing, it was below $5 million for an individual. And a lot of people would say, I don't have $5 million. But by the time you add up that retirement plan, that residence, maybe you got a second home, you've got some stocks, things of that sort, you could get up to that threshold pretty quickly. So, what the big, beautiful bill did is sign into law a permanent threshold. So, unless there's another bill that's passed in the future, the permanent threshold for estate tax at the federal level is $15 million for an individual and twice that for a married couple. So, what that means is if Bob has $15 million in whatever, right, between real estate, stock, anything that you can think of, and that's your gross estate, then he's going to have to worry about some estate tax and have to do some advanced estate planning. If Bob's estate threshold is below that point, then he doesn't have to worry about estate tax at the federal level.
Okay.
So obviously, for your average Joe, your everyday person, they're hearing this like this absolutely has nothing to do with me,
Right,
right? It
right.
has
You're
nothing to
like,
do with
that would
me.
be a good problem to
That would be
have.
a wonderful problem to have. I got to tell you, I don't know that I'd still be on with you, but I might be on a beach somewhere drinking Mai Tais if that was my issue. But I am here because I am with the rest of the masses who do not have estates that are worth more than $15 million, right? But I think that the takeaway from it is how important planning is, even if you don't have that money. The thing that I always tell people is your estate has to go through the same process as the people who have over $15 million, right? Now, granted, theirs might be a little bit more complicated depending on the assets, but if you have to go down to probate court, there's no special line for those of us who don't have $15 million. There's no fast track process. It goes through the same steps legally as the other estates. So even if you hear this and go, oh, the big, beautiful bill didn't do anything that impacts me, it actually highlighted the importance of why the everyday person still needs to do planning, because you don't have $15 million to draw from in waste, right? When you're going through the probate process, you want to maximize that money for whoever you're leaving it behind for, whether it's your kids, your godchildren, nieces, nephews, a charity, your sorority, whoever you're leaving your assets behind for, you want to try to maximize and not have that money sucked up in legal fees.
Right, right. And the reality is if someone does have an estate of $15 million or more, or even just a few $1,000,000, right? They probably are actively planning and trying to reduce the impact, the tax impact and other implications from the one big beautiful bill and beyond. So they may not even be in the line anyway, just because they've been actively planning to try to make sure that wealth, that generational wealth passes on, right? So we're
That's
the only
exactly
ones
right.
left sort of with our little pennies and fighting over those pennies and trying to figure out who gets what.
Honestly, that's the mind shift that I talk about all the time. I'm glad you mentioned that. The folks that have that money, they're doing the planning, right? We're not, but we don't have the same resources. We don't have the same assets, whatever wealth. It could be a home that we want to leave down. That's passing down wealth. That's generational wealth. So
Mhm.
why have that process interrupted or even lose the home because we didn't do proper planning? So we need to take the mindset shift and say, hey, wait a minute, it's not only for rich people, right? It's for me. I've desperately got to do this because I don't have those assets and resources to fund the things that the Bob with $17 million does.
Right, right. And so that's great context for this conversation. And even if we're looking at the news and we're like, that doesn't apply to me, taking the note of like, oh wait, maybe this is a sign that I still, based on whatever I have in terms of assets, still need to do some planning. So let's take a step back and really just not assume that our listeners know what it means when we talk about estate planning, wills, trust, et cetera. Give us a basic law school 101. What are we talking about when we're talking about estate planning, and what are the
Yes.
components of
So
that?
estate planning is really just planning for the disposition of your estate. And your estate is whatever you have. And I'm going to be completely honest with you. It bothers me. The term estate planning bothers me because when
Mhm.
people hear it, they assume that you have to be a millionaire, right? Your last name has to be Rockefeller or something like that for you to do estate planning. And it doesn't, because your estate is whatever you have. So I always say, if you have a chime account in a car, you have an estate. Congratulations.
Okay.
Or you need to plan for what happens with it. You need to plan for who's going to manage it. You're going to need to plan for who's going to get it, how they're going to get it. And it's important because if you don't, then state law, wherever you are, is going to dictate what happens with your things. And that may not be what you want.
Right, and not only will state law dictate it, but it also could get caught up in the state law and court process, which means you may not immediately be able to access the house or any assets that you may believe are left to you as a descendant of someone, right?
Yeah, so important. I think the where I see it come up most, bank accounts, money in the bank, right? So folks didn't do their planning. An account was in Mary's name alone. She had that and some other things. And folks are even maybe trying to get access to bury somebody sometimes, right? And they can't get access to that money. Or they're trying to take care of some final expenses or other things. Maybe there are dependents somebody left behind and they need access to money. The court process is not picking apart saying everybody has that story, right? So they're
Mhm.
not cherry picking to say, well, this story sounds exceptionally sad. We're going to waive state law and
We're gonna
allow,
expedite
we're
your
actually going to
process.
throw the law away and let this person do, because I am just so impacted. We wish that could happen, right? But that's not
Right.
how it works. So yeah, the accessibility of things and being able to just handle business, right? Even if it's not a bank account, even if you're in mom's house still, right? And you were living there, but let's say she had a mortgage company's not even going to talk to you, right? If certain things are not in place for you to figure out what the next steps are.
Okay, and we definitely want to delve more deeply into some of those topics. But just backing up again, so estate planning is all about the disposition of assets at a person's death. What are the components of an estate plan? Sometimes people are like, "Oh, I just need a will," or "I just need a trust," or "Oh, I just need power of attorney." Give us kind of a big picture overview of what the components are of a complete estate plan.
Absolutely. And one of the things that I also drive home is estate planning is dealing with disposition of assets while when someone goes, but also while they're still here. One of the reasons why the probate court dockets are so heavy is because of guardianship and or conservatorship matters. And depending on your state, it may be called something different, but guardianship is who makes decisions for someone, their medical, their placement decisions if they're unable to, and then conservatorship is dealing with their property, right? So if you don't have the appropriate documents in place, which are powers of attorney, then someone's going to have to go to court for you to get guardianship and or conservatorship to manage your affairs until you are able to, or if it's permanent, right? Until you're not here anymore. So that begins the nuts and bolts of the plan. I always say everybody 18 and up needs powers of attorney. Even if you're sending your kid to college, you need to get powers of attorney for them, because mama bear, even though you're still mama bear, is not going to have access to certain things after your kid is no longer a minor. So
Mm,
that's the beginning stage, 18 and up,
okay.
powers of attorney. And then will or a trust is really going to depend on what your assets are and what your specific wishes are. So if folks have minor children, if they have adult beneficiaries with special needs that get government benefits, if there are things that you want to control after you leave. So let's say, even if you do have adult children and they aren't on any sort of government benefits, or they're not living with disabilities, but maybe you just don't want them to get a large pot of money at 21, right? Because that's still pretty young. If you
Mm,
want to plan for that, then that's a trust. That's what a trust is for. Whereas a will, it's essentially just an instruction sheet. So the thing that blows people's minds all the time is when I say a will does not avoid probate court. It doesn't.
okay.
It's good to have. If you have nothing else, it's good to have, because at least it directs who I want to manage my stuff and where I want it to go, but it's not going to avoid probate, right? It's just going to tell the
Okay.
court what to do after the process is complete. So some folks may have powers of attorney in their plan, and then they may have a trust in a will. Some folks may not have the assets to justify a trust. Maybe what we're doing is getting powers of attorney, a simple will, and then making sure beneficiary designations are in place on
Mhm.
bank accounts or life insurance policies, things of that sort. So the nuts and bolts, I always say, are powers of attorney. There are pretty much no exceptions. Anybody that has sound mind to do an estate plan should have powers of attorney, and then maybe a trust and a will, or maybe just a will, depending on your specific situation.
And also a healthcare directive, right? Part
Yeah,
of it.
depending on your state, those terms of arts are going to be different. So in Michigan now, we say healthcare power of attorney, but it's also designation of patient advocate, right? And within that, we have living wills, which are different than a last will and testament, right? So when we've been saying will for the last couple minutes, I've been talking about last will and testament, that instruction
Mhm.
sheet that says, hey, here's what I want to happen with my stuff if I pass away. Whereas a living will is getting at end of life. I've gotten in a state where I'm in persistent vegetative state, irreversible coma, where I can't communicate if I still want to be on life support. But I don't want my family arguing. I don't want my husband arguing with my sister about what I said back in 92 at the family barbecue, if I'd want to be on life support and for how long, right? So that's the purpose of those documents. So you have the
Mhm.
powers of attorney for finances, and you have them for healthcare. Depending on what state you're in, it may be called something different.
Okay, and then just to be absolutely clear, of those different components of a potential estate plan, what part of it makes sure that you, your family, those that are taking care of your business while you're living or upon your death, avoid well, I guess on the death part, avoid probate? Do
So
you
it's going
need
to be the
yeah, what's
trust.
the key part? Is the trust. Okay.
Yeah, it's going to be the trust out of the documents that I name, because again, powers of attorney are while we're here. When someone passes away, they no longer have effect. So if someone has passed away, we're looking at what tools can avoid probate the best possible way to avoid probate court without causing unnecessarily family drama that we may not know about. And I'll talk about that in a second, is a trust, right? So I
Okay.
compare a trust to a flower vase, and I say that your assets are the flowers. So your house is a flower, your bank account is a flower, your business is a flower. And as long as we make sure the flowers are in the vase, they get to pass how you want, and we get to do it without the court being involved, right? So that's the
Mm,
general concept behind a trust. The reason why I mentioned before, sort of those unintended consequences that can come up, some folks may say, you know what, I'm not going to bother with the trust. I'm just going to leave this person directly as beneficiary on the life insurance policy. I'm going to leave my oldest son, and he's always been responsible, and then he's going to do the right thing, and he's going to make sure that everybody gets what they're supposed to get. Newsflash, I'm still in business because he never does the right thing.
we were talking about the what part of an estate plan ensures that a person or family is able to avoid probate, having their estate decided by the state and in the courts and possibly delayed for months or years after someone's death. That's a trust. But some families, some individuals are under the impression that if they just have power of attorney or beneficiaries or what have you, that that's enough to avoid probate. Then we have a son. You leave your son Mike or Mikey, and you think Mike is the oldest, he's responsible, he's mature, he's going to do the right thing. Pick up from that cliffhanger. Tell us what are some of the potential pitfalls of just making that assumption that Mike or Mikey's going to do the right thing.
Yes, yes, yes. I think Mikey, the classic scenario is someone that has life insurance, right? And they name Mikey as beneficiary. He may have a couple of other siblings, and mom may have said, "Hey, if something happens to me, I'm leaving you over everything, but you got to make sure to split everything equally amongst brothers and sisters."
Maybe describe a scenario. Mom probably has a house. She worked hard to be able to
Sure.
buy a house, maybe a single mom, or
Yeah.
maybe married and their father passed at some
Yeah.
point.
Maybe she's a widow and now she has the
A
house now.
pension, her post office pension.
She has her pension, she had an insurance policy, she may have a checking and a savings account in her house, right? So we're
Mhm.
not talking about above the $15 million threshold. We're talking about an
Right.
everyday hardworking woman. And she figured, okay, now that I've gotten this stuff here, I'm going to trust my oldest son if something ever happens to me to make sure that everything's split equally.
Oh, and
If
she probably
mom,
has one of the siblings probably lives with her
oh,
in the
always
house. Right.
in the
Okay.
house. Always. Never not. That there's always one. Sometimes
Right,
there's
right,
two. Sometimes there's two
right.
or three, but there's
But
always
doesn't
one
make
that's
enough
living in the
money
house.
to keep the mortgage up.
Exactly. Or it doesn't work at all. And these are so this is also like so this is the fact pattern that just keeps growing, right? So mom adds Mikey, let's say she puts him on the deed to the house with her, right? And then she adds him on the bank accounts. Then she puts him as beneficiary on the life insurance policy. And her expectation is when she passes away that Mikey makes sure that everything is split evenly between him and his siblings. The thing is, Mikey is under no legal obligation to do that. Once you
Mhm.
name somebody as a beneficiary, it may be called a TOD or transfer on death at your bank. It may be a POD or payable on death at your bank. Once you leave somebody as POD or beneficiary, the check automatically gets cut to that person. They are under no legal obligation just because mom always said, mama said at Christmas that we're supposed to all get equal money from the bank account. Mikey is
Mhm.
under no obligation. So oftentimes people think, let me just do this. I can trust him. And the one thing I can tell you doing this 17 years, even if that was your favorite and you're a good boy, at the end of the day, things change people. And it doesn't have to be what we consider life changing amounts, right? So it doesn't have to be that mom had $10 million to leave behind. It may not be that much, but it's something. And death and money does something to people. And
Right,
that's
right.
exactly why probate gets so explosive. So I think trying to avoid any sort of planning and doing the beneficiary designation route gets folks in a lot of trouble. With houses too, though, you mentioned Mikey or whoever may live with mom. And what
Mhm.
ends up happening
Oh,
is
no,
over the
Mikey's successful, he's doing his thing. He's actually irritated that mom is still helping take care of 1 or 2 of his siblings and not holding them accountable, right? And so, Mikey may not have the same commitment to his sibling or 2 that's still living with mom that mom had, right?
and Mikey may want to sell the house. So this is a
Right.
thing that we deal with all the time in probate. Mom didn't do planning at all, right? So she didn't add anybody on the deed. That house goes to probate court because that's typically the rule of thumb. If something's in your name alone when you pass away and it's not another owner or a beneficiary on it, it has to go through the probate process. So if mom didn't leave anybody on the house, it's going to probate. And that one son that's living with her, who she's still taking care of after all these years, he's not working. Or if he does, he keeps the job for a couple months, he quits, but he's well taken care of. But he feels like this is my house, right? Because he's been living there his whole life. He never left.
Mhm.
Mom's still taking care of him. And so, what happens a lot of times in probate court, we have to unfortunately end up evicting relatives from their own mother's homes, right? Where they've
Mhm.
laid their head for 35 years, 40 years, sometimes 60, depending on what families we're dealing with. And so they're thinking, but I live here. And now, since mama has died, I'm the one that's paying the taxes. I mow the lawn. I'm the one that does the snow removal. Michiganders,
Mhm.
snow
I
removal.
helped take
It's a
care of
thing.
mom.
You all weren't taking her to doctor's appointments. I'm the one that was with her. And all of that is compelling for what makes you maybe a great child, right? You took care of mama in the end, but that doesn't give you a legal footing, right? You don't get a foot up over Mikey just because you took mom to her doctor's appointments. That's not what's written into these state laws in terms of what happens to property. So you
Hmm.
being mom's favorite, you being in the house with her, you actually being her caregiver. You may have been changing mom's diapers and feeding her and doing a lot of the tough stuff that comes up when someone's sick and or at end of life, but that doesn't give you priority over someone else. And a lot of times that relative that's living in the home does not have the means to pay the mortgage, to assume it. They can't keep up with the property taxes. They can't keep up with the upkeep of a home. Anyone that owns a home knows that there's always something. As a homeowner, and the
Right.
child that's living in the house may not be able to handle that. And so what does Mikey want to do? Mikey wants to sell the property. Why would he want to hold on to it? And then that creates friction. So that is one of our age old stories that we deal with weekly in my practice.
Right, right. And then maybe in the reverse, maybe Mikey left. He didn't really stay in touch with mom. He's sort of a distant child. And mom wants to make sure that the kid or kids that were there for her really are the greater beneficiaries to her estate, right? So,
Right.
but if she dies without a trust, then Mikey could get equal benefit as the other sibling or two, right?
Exactly. This is the reason why we say plan, right? Because if you don't plan, then state law is going to say what happens, and it's not going to matter that your son has not come home or checked on you in 15 years and he's absent. He's going to have equal standing as his other siblings. So that's why it's so important, to your point, to do the planning. I have folks that regularly say, hey, this one, I only want him to get 20% as opposed to 33 and a third if I had three kids. So the
Mhm.
thing is, the world is your oyster when it comes to planning. You can plan for your specific situation. Families aren't perfect. We don't choose them, but they're ours, right? And you can plan for it, right? You know
Mhm.
your kids, you know your siblings, you know your aunts,
Right.
uncles, and whoever else that are in your network, in your family, that would be left behind if something happens to you. So you got to plan for it.
Right, right. And then mom may have a kid, maybe mom dies relatively young by some comparisons, right? And maybe a kid or adult that has special needs and maybe mom wants to plan for the care of that particular child. Not that she has anything against the other children, but she especially wants to make sure she plans for the care of that child.
So, and that's where a trust is super important. So,
Mhm.
we in Michigan, we call them special needs trust generally. And so, what that will allow someone to do is care for their adult child that is living with a disability, for money to be set aside for someone to manage and sort of supplement their needs, right?
Mhm.
And they don't get kicked off government benefits. So, if someone's on Medicaid, and mainly people need Medicaid for a lot of different things, but it's going to be for health benefits, right? That's how people are able to go to the doctor if they don't have money through Medicaid. Maybe someone's getting special therapies, right, through Medicaid. If you don't want them to get kicked off, you have to have a trust, because if you leave that adult that is living with that disability as a beneficiary directly, that's income that's coming into them. Of course, the government's not going to continue to pay, right? And is the money that you left behind big enough to carry their healthcare needs for the rest of their life, right?
Attorney Crump-Gibson, we talked about the good son Mikey and kind of relying on Mikey to do the right thing and why that may not be the best way to go about ensuring that your estate plan passes in the way that you want to. Within that is sometimes someone will pass and they have minor children. A parent will pass and they have minor children. What are some critical things to think about when you have small children or under the age of 18?
So I tell folks all the time, if you have kids under 18, you absolutely need to get a trust, right? Because you want to make sure that any money that you leave behind, no matter where it's coming from, is going into a pot that someone can manage without court supervision. Again, we're talking about probate avoidance. And so what people will do is they'll get the insurance policies, they'll set up the annuities, the accounts, as they start making a little bit more money, and they'll put their minor children on his beneficiaries. And so that may avoid probate court on one end, because if something happens to you, it's not a probate asset because it's something that had a named beneficiary, right? And those things typically don't tend to go to probate court. However, you won't avoid it on the back end because there's not going to be a financial institution out there that's going to cut a check directly, a large check to a 7-year-old. A 7-year-old is not getting a $500,000 check. And typically,
Mhm.
what those
Or
financial,
even a 17-year-old,
or even a
possibly.
17-year-old, right?
Mhm,
Anyone that's not the age of majority. So if you're not
mhm,
18 and up, then this applies to your child or grandchild or whoever else you're going to be providing for. And so what will happen is they'll name them as the beneficiary. And then here comes the insurance company or the financial institution. And they say, oh, okay, she had this policy. This is the amount of the death benefit. You're going to have to go to court and get some paperwork to show that you have legal authority to manage this money for this child before we even send a check out. And so that's probate court, right? So we have not avoided probate court because we named the minors as beneficiaries. So if we set up a trust, we don't have to worry about that. The other piece of it is guardianship. So who's physically going to take your children if something happens to you and their other biological parent? And I focus on this, it's super important because if you are not with your child's biological parent, and their parental rights have not been terminated, they get your kid. So a lot of folks love to tell me, oh, she's a deadbeat, he's a deadbeat. They haven't been around, they don't really have a relationship. Unfortunately, those parental rights are not severed just because someone is not dad or mom of the year, and they're still going to have priority to take their kid if something
mhm,
happens to you, right? So going a step beyond that, you're going to want to designate who you would want to physically take your kids if something happened, because what we deal with is grandparent wars, auntie and uncle and wars. So it's grandma on this side. Well, I want to be the one to take so and so. I'm the one, I'm more stable. I live here. They wouldn't
mm,
have to do this. And you can imagine how contentious that can get in probate court. So to avoid
mm.
that, you need to sit down with your co-parent, whether that's your spouse or life partner or not, and have a conversation about who do we trust our kids to go to, and name those folks in your document so that process is seamless and it's one less probate fight.
And just one clarifying question on trust. My understanding is that there's a certain asset threshold by which you need a trust. Like if you're, I think in California, if your estate's under $300,000 or something, that you may not need a trust. Is there a misnomer in how we understand that?
Yeah, that's definitely a misconception. You can put
Okay.
anything, any assets in a trust. And I think that's what gets folks thinking, well, that's not for me, right? Because I don't have millions of dollars, so I wouldn't need a trust. But again, you can have that chime account and you can have a house and an insurance policy. If you
Mm-hmm.
have minor children, we still need to do a trust. So it's really dictated by what your family situation looks like and what your specific wishes are, not just your assets. What you do have is part of the conversation, right? But it's not the only part of the conversation. We're digging into specific wishes to figure out if the trust is the right tool for you.
Statistics show that 56% of Americans still have no estate plan, and that many, to the extent we're doing it, many are going to AI now to have our wills generated and online resources. What are some of the problems with that, and why do folks need to consult with someone like yourself?
Yeah, I mean the thing with AI that I tell people is the output is only going to be as good as the input, right? So even if I'm talking to AI, that's going to be completely different than someone that doesn't have my experience and my background, because what I'm going to say is going to be very targeted, specific, include law, right? Where is you don't know what you don't know, right? So if you're somebody that is not an attorney with specific experience in probate and estate planning, so not the DUI lawyer, not our amazing injury lawyers and criminal law lawyers, but ones with that specific expertise, the output may not be what you need, right, to protect your assets and avoid probate court. But in general, I liken AI to going and getting a boilerplate document off Google, right? It may work, it may not, right? But working with AI and Google, they're going to ask you targeted questions, right? Because it's smart enough to do that. We know technology, but you may not know how to answer those questions or ask certain follow-ups, right? That may get the information out there for the AI to generate something that's tailored specifically to you, and your estate plan needs to be tailored specifically to you. So you may get a document that looks good, right? It has all that legalese, the fancy words, it's kicked out 30 pages, and you've gone and gotten it notarized and you think you're in good shape, but it may be missing, right, some major provisions. It may be silent on some things that need to be there. And in any legal document, if provisions don't address something, the only place you can get that resolved is a court, right? So what is the reason why we did this trust in the first place? To try to avoid probate court. And we end up there anyway because your AI document didn't cover something that's special, or it did cover it, but not in a way that you thought that it was going to play out. So
Right,
I
right.
think the dangers of those things are just not having something that's tailored specifically to you, right? And again, remember, whatever you do, if you're a teacher, firefighter, baker, you are great at what you do. If you don't do this, you just really don't have that requisite expertise. So I tell folks, at least consult with the lawyer. Even if you're not going to retain them to do the whole process, and I highly recommend that you do, at least consult so that you can understand based on what your specific wishes and what your family looks like, what you should be doing.
Right. And no disrespect to those that work in the document preparation industry or paralegal industry, but even that you want to have someone, a lawyer, giving the final insight and input on your trusts and your estate.
100%. I have a probate case right now where someone trusted their daughter, who was a paralegal, to draft a will. And you know what? I don't even want to talk about it. I don't even want to talk about it.
Speaking of which, what closing words would you have for our audience?
Yes, my closing words are estate planning is an act of love, right? This is about love and legacy. Look at this as not, oh, it's morbid. I don't want to talk about it. I'm going to be jinxed. If I get my estate plan done, I'm going to walk out of the office and get hit by a bus tomorrow. People have said that to me. So they think about those things, and there's so many myths floating out there, but just think about whoever your family is, right? It may be your neighbor of 50 years down the street. You may not have kids, right? Everybody's family doesn't look the same, but you want to make sure that you're leaving a legacy behind, and it's not muddied by the probate process. It's not, or that the asset is still around and doesn't get liquidated during the probate
Right,
process, right?
right.
So what I want to leave behind is for folks to say, listen, everybody needs a plan. Do not be intimidated by the process. This is an act of love. It's an act of legacy. And this is how we can actually build generational wealth in our communities, by taking the time to plan so that things can pass to future generations.
I love that. I love that. And how can people find you or follow you online?
So you can find me on Instagram as fashion. It looks like Fashion Lawful. So Fashion Lawful One. Our firm is Great Lakes Legal Group. So you can find us across Facebook, Instagram, LinkedIn at GL Legal Group. If you can't remember any of that, just Google my name. My personal website is jehancrumpgibson.com. But if you just type my name, Jehan Crump-Gibson, in Google, you'll be able to find me.
Excellent. Thank you so much, Attorney
Thank
Crump-Gibson,
you.
for coming on today. You've been an amazing guest and definitely look forward to having you return and staying in touch.